Hello everyone. In this video by Garvit.com, we will be discussing an issue which has been in contention forever, the Armed Forces Special Powers Act or AFSPA. First of all, the Armed Forces Special Powers Act was passed in 1958 to tackle Naga insurgency, which was later extended to other regions. Basically, it gives sweeping powers and legal safeguards to forces for undertaking counter-terror operations in what the Act terms as disturbed areas. So basically, under the Act, certain areas are designated to be disturbed areas in which AFSPA is then imposed and which give sweeping powers and legal safeguards to forces. It is currently in Northeast and also Jammu and Kashmir. So the controversy basically is that it has been criticized for alleged concerns about human rights violations. So people say that wherever AFSPA has been in force, there have been cases of murders, rapes, torture and various other human rights violations. The J&K government formation was the reason why AFSPA recently came into news. So to get into a little bit more detail as to what are the provisions of AFSPA. Firstly, there is a section 4 with special powers of the armed forces. It allows the armed forces to search premises and make arrests without warrants, use force even to the extent of causing death, destroy arms dumps, hideouts, and to stop, search and seize any vehicle. Now, to understand how different they are from the other states, we need to look at what provisions exist in the other states. In most of the other states, it is the police which has most of these powers, and that too with civilian oversight. So some magistrate, whether executive or judicial, will be there to issue warrants. So the police cannot arrest without warrants. Similarly, for any searching or seizing or any of these activities, the police does need some warrants or some permission from the executive magistrate or the judicial magistrate. So while in the other states, these operations are undertaken by the police which are local to that particular state, they also have the oversight of the judicial or executive magistrate. But in areas where AFSPA is imposed, it is not the police which the people still consider to be local. It is the army which is doing all these things, and there is no oversight because they do not require warrants, and they can, because it is considered to be a case of emergency, they can do all these activities without basically any oversight from any other agency. Then there is section 7 which says protection of persons acting in good faith. So this basically means that there will be no prosecution, suit, legal proceeding or anything except with the previous sanction of the central government against any person in respect of anything done. Now this is again a major bone of contention, because this says that if an army personnel is doing something or has done something which is considered to be in good faith, there can be no prosecution or legal suit which can be initiated against that person without the sanction of the central government. And needless to say, the sanction of the central government is very rare to come by. So what happens is, if there is, let us say, a murder, then the problem is that under normal circumstances, the law of the land would imply, and the person who has been implicated would be prosecuted against. But in the case of AFSPA, if the murder was committed in the course of the duty of that person, and it will be assumed that this was done in good faith, and you require central government's previous sanction to initiate any proceedings against that person. So which effectively means that if there has been a wrong done by a person, it is very difficult to bring that person to book. Just to get into a little bit of history, in 1958, this was first imposed to tackle Naga insurgency in the erstwhile Assam and Manipur states. In 1972, it was extended to Assam, Manipur, Meghalaya, Nagaland, Tripura, Arunachal Pradesh and Mizoram. In 1983, it was imposed in Punjab and Chandigarh, where it was withdrawn in 1997 after 14 years. In Jammu and Kashmir, it is there in 6 districts initially and within 20 kilometers of the LOC in Rajouri and Poonch. The 6 districts were Anantnag, Baramulla, Budgam, Kupwara, Pulwama and Srinagar. In 2001, it was extended to Jammu, Kathua, Udhampur, Poonch, Rajouri and Doda. So in case of AFSPA, the stakeholders are the affected states, the armed forces, central and state police organizations, human rights groups, legal fraternity and the central leadership. The public perception about AFSPA is that it is anti-people. It gives the armed forces the license to act with impunity and they commit human rights violation without any accountability. But the problem more than the law is the insensitive approach. More sensitive approach towards the alleged human rights violation would have served to prevent such a perception from taking root. So it is not necessarily the act which is the culprit, but it is the sensitivity or the lack of it of the people implementing that act which has given rise to this whole situation. If let's say there is a human rights violation, perceived human rights violation, if the people were brought to book, if the people who were perpetrators of a heinous crime were brought to book and they were punished, then this perception that the army is behaving in a very insensitive manner or in an autocratic manner would not have taken shape. So that is the whole problem. Okay, in the viewpoint of the people who are against AFSPA is that in a democracy the army must be employed only for limited periods and its deployment cannot be prolonged indefinitely. Any area is supposed to be governed by a democratically elected government and you cannot transfer that responsibility to the army saying that okay, because we are unable to take care of the territory, you govern it on our behalf. This is sort of the perception which is there for AFSPA. Nagaland, which is still designated as disturbed, despite the fact that hostilities have been suspended for over a decade and no security personnel have been killed in this period. So the issue is not only that AFSPA is imposed once when there is a disturbance in the area. The issue is how often or not is it reviewed. Whether once the pertinent or the imminent danger is over, is it revoked or is it just status quoist way it just continues forever. It has become an excuse and an alibi for poor governance. And basically in a democracy, public opinion and perceptions must be taken into account while examining whether a particular act needs to be reviewed or even repealed. The government appointed the Jeevan Reddy Commission. Now before we go to the Jeevan Reddy Commission, I would like to point out what are the points in favor of the AFSPA. The army says that you are putting us in a situation which is not natural for the army. The army is trained to counter the armies of alien or enemy nations and they are supposed to behave in a certain way. Now they are not really adept at handling civilian situations. So they are saying you are putting us in a situation like this and also you are placing a lot of responsibility on us. You cannot then curtail our powers. If you expect us to stop terrorists from conducting major operations, you do have to give us search and seizure operation rights. If you do not, the army says we cannot be going to civilians or the magistracy or anybody for warrants because in the meanwhile people will be executing major crimes. Similarly, when the army is put in a situation like this, there would obviously be strikes wherein terrorists will be killed. If the army or the army personnel were to be tried for each murder committed or each so-called offense committed, then it will be a real lack of morale. It will be a hit to their morale of the army personnel, and the army personnel will not be able to function in such a scenario. So to prevent victimization of the army personnel, it was said that the AFSPA would give protection to the army personnel in case of good faith actions committed by them. So the problem was not in the thinking of AFSPA, but more in the implementation. So Jeevan Reddy Committee reviewed the AFSPA and the recommendations were as follows. Basically, they had hired the General of the Indian Army as one of its members, and the committee unanimously recommended the repeal of AFSPA and its replacement by appropriate amendments in the UAPA. The committee said that the act, for whatever reason, has become a symbol of oppression, an object of hate and an instrument of discrimination and high-handedness. It also pointed out that the protection from legal proceedings against soldiers acting in good faith already exists in section 49 of UAPA. There is a need to balance protection against civil or criminal with knowing abuse or misuse of powers. So they said that it's okay to give protection against the civil or criminal acts, but knowing abuse or misuse of powers needs to be checked. They were in favor of amending UAPA to incorporate measures that would regulate the already permissible conduct of armed forces personnel. So in JNK, in the recent days the issue has been. BJP has been saying, or the BJP's view is that there would be no compromise on AFSPA, as it was not just the army which was a stakeholder in the issue, but the entire country. But the PDP says that gradual reduction of the military presence in the state and the army being replaced by the local police in areas where the security situation has improved. So Chidambaram in 2013 had said that we can't move forward because there is no consensus. The present and the former army chiefs have taken a strong position that the act should not be amended. Apart from the Jeevan Reddy Commission, Mr. R.N. Ravi, former head of the Intelligence Bureau for the Northeast, is on record that the AFSPA is the biggest obstacle to peace in the region. Similarly, another strong voice of Mr. G.K. Pillai, former Home Secretary, has come out openly against the act. So as you can see, the army is very much in favor of the act, but there are various voices which are against the act. So in a conclusion, one could say that as a law there is nothing wrong with the AFSPA. It is its functioning which has given rise to resentment amongst the masses. The acts of the few soldiers bringing disrepute to the act as well as the army. The army authorizes authorities should adopt a policy of zero tolerance to the misuse of the law by its men. So it is like anything else. It's not the law, but it's the misuse of the law which is basically causing this problem. So if the army were to take strong action and immediate action against people who are found to be violating the law of the land with impunity, and if the army were to punish those people, then AFSPA would not be resented so much in the valley in general and in the whole country in fact. But on the other side, those who demand its repeal do not ask the army to leave any region. They only want the armed forces to serve the country under the constitution without a law that allows abuses with impunity. So the other part says that okay, let's not leave the implementation of AFSPA to the army, and let's just give the army a law which is not above the constitution and which gives equal rights, or in fact it takes into account the rights of the people along with the rights of the army. So in this we just try to summarize the views about AFSPA. You're welcome to have your own view on it. Thank you. I hope you liked the video. Please subscribe for more such videos. Thank you.